Judge Jackson, there are two issues that came up repeatedly yesterday from the other side of the aisle that I want to address at the outset. One of them was a question of judicial philosophy. No one questions either your academic law school credentials or your service as clerk and as federal judge, but time and again you have been asked, what is your judicial philosophy? Does it fit into Scalia's originalism, Kavanaugh's textualism? Is it strict construction? Is it liberal? Is it conservative? Lo and behold, I've discovered the answer. It turns out that during the course of your time as a judge, you have actually had written opinions, 573 to be exact, I think. Maybe I'm off by one or two. And they more or less express your view of the law as the facts are presented to you in each one of those cases. And then some 12,000 pages from the Sentencing Commission, transcripts of deliberations on important issues. For most of us as elected senators, if people asked, what's your philosophy, we'd point to our voting record. You have a record when it comes to court decisions. And this committee, for the fourth time, is delving into everything that you've published as a judge and even before. So would you like to comment at the outset of those who are looking for a label, what your position is on judicial philosophy?
Yes, thank you, Mr. Chairman. Over the course of my almost decade on the bench, I have developed a methodology that I use in order to ensure that I am ruling impartially and that I am adhering to the limits on my judicial authority. I am acutely aware that as a judge in our system, I have limited power, and I am trying in every case to stay in my lane. And so what I do is I essentially follow three steps. The first step is when I get a case, I ensure that I am proceeding from a position of neutrality. This means that you get a case and it's about something and it's submitted by certain parties. I am clearing my mind of any preconceived notions about how the case might come out. I'm setting aside any personal views. It's very important that judges rule without fear or favor. The second step is once I've cleared the decks, so to speak, in this way, I am able to receive all of the appropriate inputs for the case. That is the parties' arguments. They've written briefs. Sometimes we have a hearing. Sometimes we hear from other parties, amici in a case. And then there's the factual record. I am evaluating all of the facts from various perspectives. I think my experience, all of the various experiences that I've had, really helps me at this stage to see the perspectives of all of the parties and to understand their arguments. And then the third step is the interpretation and application of the law to the facts in the case. And this is where I'm really observing the constraints on my judicial authority. There are many constraints in our system, importantly, because judges have limited authority. And so I am, first of all, looking at my jurisdiction. Threshold matter in every federal case is to make sure that you even have the power to hear the case. In evaluating jurisdiction, you're looking at all sorts of things, the text of a jurisdictional provision, for example, precedent related to it. If I can get to the merits of the case, if I have jurisdiction, then I am observing the limits on my authority concerning the question. So if it is a statute, for example, or a provision of the Constitution, I'm looking at the text. The adherence to text is a constraint on my authority. I'm trying to figure out what those words mean as they were intended by the people who wrote them. So at this point, I'm looking at original documents. I am focusing on the original public meaning because I'm constrained to interpret the text. Sometimes that's enough to resolve the issue in terms of the merits. Judges also look at history and practice at the time of the document was created. If it's a statute, I'm looking at Congress's purposes, because again, I am not importing my personal views or policy preferences. The entire exercise is about trying to understand what those who created this policy or this law intended. I'm also looking at precedent, which is another constraint on judicial authority. I am looking at prior cases and trying to understand what other judges have said. As a lower court judge, I'm bound by the precedent. And even in the Supreme Court, if I was fortunate enough to be confirmed, there's stare decisis, which is a binding kind of principle that the justices look at when they're considering precedents. So all of these things come into play in terms of my judicial philosophy.